Robert Mueller is still playing fast and loose with evidence, and at least one of the judges in these cases is not having it. Mueller is really playing games, and this guy won't stop. Of course, I'm talking about Robert Mueller, the special counsel. Now Mueller is playing games that I've frankly never seen. I always tell you, I've been affiliated with or covering on-air law enforcement issues, intelligence issues for 25 years now. Started doing it when I was like literally early 20s. I joined the NYPD in my last year of college. I was going to school at night. So I've been doing this my entire adult life in some fashion. And I've never seen anything this bad. So now, a story from the Hill. Judge rules Mueller must identify unnamed individuals in Manafort indictment. You have a constitutional right to face your accuser. It's one of the most fundamental rights, one of the most basic rights, one of our oldest rights. A constitutional right to face your accuser. Let me read you this, how troubling this is. Another case going on when Mueller wants to. Mueller is actually asking the court in another case we're going to talk about in just a bit to let him withhold evidence from those individuals charged. It's unheard of. Withholding exculpatory evidence. It's saying, I'm gonna hold everything back that might help you. And then you need to go and mount a defense without any of the evidence we've collected that you're entitled to according to the federal rules of criminal procedure. It's bizarre. So here's the first story. A federal judge ruled Tuesday that special counsel Robert Mueller must identify the unnamed individual in his recent superseding indictment of former Trump campaign chairman Paul Manafort. Now, you remember that there was a superseding indictment. He indicted Manafort again, though it was the superseding indictment. It's the new indictment that's a catch-all, that in addition to all the financial crimes Mueller had previously been indicted on, he was now being indicted on witness tampering because of a couple of meaningless phone calls. Maybe he meant to do it, maybe he didn't. I don't think, and people like Andrew McCarthy and legal giants didn't think that there was anywhere near enough evidence to charge him again. Now, Mueller indicted, well, it was like last week, Mueller indicted Manafort and a guy named Konstantin, Kilimnik. And it was, they were indicted on charges related to lobbying work in the Ukraine. You know that story. However, the new issue here is, let me read it to you. Judge Amy Berkman Jackson ordered Mueller to turn over the names of several individuals and organizations, including European politicians and other Manafort contacts to Manafort's attorney, according to court documents by Politico. The New York Times reported last week that two veteran journalists told Mueller that Manafort attempted to contact them, and try to shape their testimony. 3 Time sources identified the journalists as Alan Friedman and Eckhart Sager. Mueller's indictment did not name the witnesses that Manafort and Kilimnik allegedly contacted. The judge, her ruling is coming in response to a motion from Manafort's team seeking more information on the superseding indictment. Now, the judge ruled that, quote, this is pretty standard stuff, the defendant is obliged to prepare for a complex trial with a voluminous record within a relatively short period of time, and he should not have to be surprised at a later point by the addition of a new name or an allegation. And that is just a legalese way of the judge saying to Mueller, you've got to be kidding me. This is the most basic principle of discovery in a criminal proceeding. You can't tell somebody, a defendant, you're charged with these new crimes, but we're not going to tell you how we got that information. We're not going to let your lawyers do their job, cross-examine those witnesses, depose those witnesses. We're not going to let your private investigators look into this. We're not going to give your client a chance to mount the defense by saying, I never spoke to that person. Or, yes, I spoke to that person, but what that person didn't tell Mueller's team is that there were these 15 other people in the room for the entire conversation, and those 15 people will swear under oath that I never said to that person what they alleged I said. That's standard defense. Mueller is now, in my opinion, clearly trying to hide something. He has a very flimsy case against many people, and this I've never watched a prosecutor play this fast and loose with exculpatory evidence. When you combine the fact that Mueller has a long history of being admonished by judges for playing fast and loose with exculpatory evidence, as does his number two, Andrew Weissman, this becomes all the more troubling, all the more problematic. So the second story from Dan Abrams' blog, Law and Crime, and this is not a conservative outlet. This is not a pro-Trump outlet. This is even worse. Mueller is trying to hide evidence from defendants in the Russian trolls trial. Now, let me read you this. Special counsel Robert Mueller and his deputy Rush Atkinson filed a 14-page motion. They submitted that motion yesterday, Tuesday, and this is the best, arguing that the government, i.e. Mueller, shouldn't have to release certain evidence to the indicted Russian company Concord Management and Consulting LLC due to ongoing, quote, interference operations against the United States. In other words, I'm going to indict you, I'm going to charge you, but because I'm going to concoct a Russian bogeyman to say they're interfering in elections, I don't want to have to give you any exculpatory evidence for your defense. It is a ludicrous assertion. It's like the government going after somebody for organized crime, indicting a mobster, and then saying to the mobster's legal team, we indicted your client, but because their criminal enterprise is still operating, your client, unlike every other client, is not entitled to exculpatory evidence. It's not how the system works. You have to give the defense the exculpatory evidence, no matter what else you think they're doing. If you think they're doing those other things, then go charge them on those other things. But you can't withhold evidence on speculation. In their motion, Mueller's team requested a protective order to, number one, keep other co-defendants named in the February 16th indictment from accessing the government's evidence against them. It's bizarre. And it is exactly what Judge Amy Berkman Jackson told Mueller in a different case against Manafort he could not do. And number two, to keep additional evidence under the control of government attorneys and away from Concord Management itself. So Mueller wants, again, to withhold all exculpatory evidence from the main defendant as well as from the co-defendants. He only wants the prosecution to be able to mount the case. It's a very important story because it cuts to the heart of the rule of law, and things Mueller is doing are making me very, very uncomfortable, making many Americans, many people around the world very uncomfortable. I want to keep covering it. Help me do that by subscribing to our premium service at www.therebel.media/shows. Go to the App Store, download the Rebel app. As always, thanks so much for watching. I'll see you tomorrow.